Welcome to today's webinar, an in-depth review of Section 1071. I'm Dean Stockford, President and CEO of M&M Consulting, saying thank you for attending today's webinar. Today's featured speaker is Len Suzio, President and founder of Geodata Vision LLC. Len has been a CRA and fair lending consultant since 1994. He's advised hundreds of banks during that time and has written numerous published articles about CRA as well as climate risk. Len also has conducted webinars and seminars on CRA at various bank regulatory compliance conferences and has had the unique experience of having been a state senator in Connecticut State Senate, for which he testified as an expert in small business finance in front of the United States Senate. Today, Len is going to review the new Section 1071 rule that was announced by the Consumer Financial Protection Bureau in the release of 888-page document, which includes the rule, the preamble, and the official interpretation. After his presentation, Len will take questions from the audience. In fact, we've already received dozens of questions from registrants. We will do our best to respond to as many as possible. You may submit questions during the webinar by clicking on the Q&A button at the bottom of your screen and entering your question, and we will address it hopefully at the end of the presentation. Okay, Len, now you have 88 minutes to cover 888-page document. I brought my bottle of aspirin, so the show is yours.
You might want to try something a little bit stronger than aspirin. Well, as we begin this webinar, let me just dispense with the disclaimer. This presentation is for informational purposes only. Geodata Vision does not provide legal advice, neither does M&M Consulting. The content of this presentation represents the views of the author, who happens to be me, regarding the new Section 1071 rule. For legal advice related to Reg B and Section 1071, we recommend consultation with a qualified attorney. We also suggest that you visit the CFPB website on the landing page called Resources for Filers, which can be accessed at the address on the screen. Let me begin by saying that the 1071 is a reporting regulation. It's not a performance regulation. So it's very much like HMDA. It's not like CRA, which CRA not only mandates reporting, it has certain performance standards. And excuse me. So it's very, very different. But 1071 will be used for fair lending purposes and for CRA purposes. The prudential regulators have announced that once 1071 becomes effective and the compliance states are implemented, that no longer will banks be required to report small business activity, small business and small farm lending activity under CRA. The data that's going to be reported under 1071 will replace that. However, community development activity will still be subject to reporting under CRA, but the small business, small farm lending will not be. Now, today, I'm going to try to cover as much as I can of 888 pages. I'm going to really focus on what I consider to be the most important aspects of the rule and the most immediate impact and the most confusing. So let's begin. And of course, the very first thing that you want to know is what is to be reported. What are the records to be reported under the new rule? And subsection 107, which deals with the compilation of reportable data, says that a covered financial institution shall compile and maintain data regarding, quote, covered applications from small business. So obviously that raises some issues. Well, what's a covered application? So for that, you go to subsection 103, covered applications, which reads, a covered application, except as provided in paragraph B of this section, covered application means an oral or written request for a covered credit transaction that is made in accordance with the procedures used by the financial institution for the type of credit requested. This sounds like the beginning of a typical bureaucratic rule. Covered application means a covered transaction, blah, blah, blah. So we look and say, well, what are the circumstances that are not covered applications? So they don't include items in B1 and B2, which is reevaluation, extension, or renewal requests on existing business credit account, unless the request seeks additional credit amounts. And that's going to be a source of confusion for people because renewals are reported under CRA right now. Also, circumstances that are not covered applications involve inquiries and pre-qualification requests. We're going to get into that in a little while. Unfortunately, it doesn't stop there. You would hope, okay, we now know what a covered application is that is supposed to be reported, but you must go farther because a covered application covers a covered credit transaction. So we have to learn, well, what is a covered credit transaction? And 104 basically says covered credit transaction means an extension of business credit that is not an excluded transaction under paragraph B of this section. And the enumerated under paragraph P is trade credit, reportable loans, insurance premium financing, public utility credit, securities credit, and incidental credit. Now, you would think, okay, now I know not only what circumstances apply for not covered applications, but now I know in terms of covered credit transactions, what's excluded. However, this is something to make note of. There are still additional excluded transactions that pertain to 104, but are not enumerated in this specific section of the rule. It comes in the official interpretations, which on 104, which include factoring, leases, consumer designated credit, and credit transaction purchases, purchases of a pool of credit transactions, and purchases of a partial interest in a credit transaction. So even though it's technically not explicitly in 104, these additional exceptions are in the official interpretations, which means that they apply. And if you look only at the subsection 104 in the rule, you will not know that factoring, leases, consumer designated credit, and credit transaction purchases, et cetera, are also excluded transactions. And I will immediately comment that item number 4, credit transaction purchases, purchases of a pool of credit transactions, and purchases of a partial interest in a credit transaction stand in stark contrast to the way those items are handled in CRA today. In CRA today, if you purchase a small business loan that was originated by another institution, you get credit for that loan that you purchased. But 1071 is not going to trace any transactions involving a purchase loan or a purchase in a participation in the loan, et cetera. So that's going to have a pretty significant impact. And if you're a CRA reporting lender now, or even if you're subject to CRA, you will no longer be able to purchase business loans, for example, because the information won't be available in the public data, which is used for the performance context. Finally, now that we figured out, okay, what a covered application is and what it does not include, the last caveat of data to be reported is that the covered application must come from a small business. So what's a small business? Well, the small business definition is the same as the term small business concern in the regulations pertaining to the Small Business Administration Act. And their reference in the note here. And one final caveat, the credit request must be initiated by the borrower, not by the lender, but by the borrower. So you can see that the most basic information here that you've got to understand is not quite so simple to understand. You would hope, okay, we've got to report covered transactions or covered applications, and that would be it. But no, it's pretty complicated. And this is so critically important. That's why I've made it the first slide today, because you can get into an awful lot of trouble if you fail to report transactions you're supposed to report, and you ask the protected demographic information, or you don't ask for it, and vice versa. If you don't report something you should report, basically you'd be violating a COA there. So you've got to be very careful. You understand what's transactions are subject to reporting under 1071. And there's big problems if you report the wrong transactions or if you fail to report the transactions you should be reporting. So I'm going to talk about the first questions you must ask before any other questions as I get into the slides. We're going to talk about, well, who are covered lenders? What are covered lenders? We'll get more into covered transactions, and it's not the size of the loan anymore, unlike CRA today, and for the last 27, 28 years now, which has been determined by the size of the loan. A small business loan is limited to $1 million or less. That no longer applies. Basically, there is no size limit to a small business loan under 1071. There are covered transactions and not covered transactions, and there are covered applications and not covered applications. So you've got to know the difference. And I'm going to go into this stuff again because it's complicated and confusing. And I think repetition can help people perceive what they have to understand. So we'll talk about the transition rules. There's going to be special transition rules. There's going to be compliance date tiers, reporting mistakes and safe harbors. We'll talk about that. The definition of a minority, woman-owned, or LGBTQ plus owned business. We'll talk about the transaction details that be reported. I'm not going to go into all 81 fields, but I'm going to talk about a number of them. We'll talk about the publication of the reported aggregate and disclosure data, which I think is going to create some big, big problems. And we'll talk about that. I'm going to periodically have some recommended best practices. And I will talk about the potential confusion with CRA and the implications for CRA as well. And then hopefully we'll have some time for some questions from you in the audience. As Dean just mentioned, we already have a bunch of questions because we offer people to send them in advance. So what I call the Section 1071 challenge. For every institution that extends business credit, whether the institution is a covered lender or not a covered lender, every single commercial loan origination you process must be scrutinized to determine if it is a covered transaction and if it is from a small business that is subject to 1071 requirements. So those of you who think, oh, I'm not going to be a covered lender, well, that doesn't relieve you of the responsibility to monitor your commercial transactions to make certain that you don't cross the volume threshold and become a covered lender or a covered reporter. The obligation to scrutinize every business loan application applies to covered institutions. Now, that's different from covered transactions. A transaction is when you actually make the loan, but the application is only when you receive it. So if you're not a covered lender, you have to look at originations. If you are a covered lender, you have to look at applications. Business lenders are not covered institutions that are not covered institutions must annually determine if they qualify as a covered institution that would immediately impose Section 1071 obligations on the institution. These non-covered institutions must continually monitor business loan originations. So there's no relief even for those of you who are not covered, unless you don't engage in commercial lending at all. Well, that's another story. But those of you who do engage in commercial lending, and this is, again, not just banks, it's credit unions, et cetera. And I'm going to get into who the covered lenders are or reporters are in a few minutes. And I just want a note of that you should be aware of here. Increases in extensions of credit to an existing business account, in other words, a renewal, are reportable for covered institutions. But extensions of credit that are renewals do not count for activity that qualifies a non-covered lender to become a covered lender. So if you're not a covered lender, you don't have to even think about renewals because you're not going to report them. You're not going to recognize them for coverage purposes. It's only the covered lenders have to be cognizant that when they engage in a renewal, as it's defined in the regulation, that only increases in the activity or in the facility will be reportable. And I'm certain your heads are spinning, and Dean's probably reaching for his third aspirin already. Even non-covered commercial lenders need to monitor lending activity. I can't emphasize this enough. Unless you don't engage in commercial lending or you just do 2 or 3 loans a year. But if you're hovering near 100 originations of commercial loans a year, you've got to be really careful. So the definition of a covered institution has radical implications when compared to the CRA definition of covered lenders. Since covered institutions are based on transaction volumes and not asset size, this is a big distinction with CRA. CRA, you didn't become a reporter, a mandatory reporter, until you reach a certain asset size, and you knew when you reached that asset size. But under 1071, it's all going to be based on the volume of originations that you're doing. And so therefore, all commercial lenders, even those that are not covered, have an obligation to monitor all commercial loan transactions, meaning originations, to determine if they have crossed the covered origination threshold that would trigger institutional coverage. And after the transition period, when there's going to be a phase in for the larger institutions first and then the smaller ones, the threshold will be 100 originations of covered loans to small businesses. There are special transition rules pertaining to who qualifies as a covered lender until the beginning of 2026, at which time anyone who is doing at least 100 covered originations per year will become a reporter under 1071. And again, I want to say, after the transition period, once you become a covered lender, your data collection responsibilities commence immediately. Immediately. This means that you will need to have a 1071 data collection system in place and ready to go on January 1st, the day after you have originated 100 or more covered transactions for the second consecutive calendar year. There is no delay in your responsibility to begin collecting the data that you will have to report in the following year. So don't sit back and just think, okay, I'll have another year to get my act together. If you're getting close and you're in that second year, you already did 100 originations in the first year, you're likely to become a covered lender by the time that the second year ends. And you will immediately, on the very next day, have responsibilities of a reporter, a mandated reporter. So what's it all about? Section 1071 mandates collecting and reporting data on, quote, covered applications from small business borrowers, including some information that's ordinarily illegal to collect. Now, you got to remember, again, that you're being ordered to collect information that's ordinarily illegal to collect if you're processing a covered application from a small business. So you've got to be very, very careful about this distinction I was talking before about covered applications under 107 and covered applications, which are the definition in 103, and the excluded transactions under 104. What applications / transactions are covered not only make it legal to collect certain information, but mandatory to request it. Well, basically, you're required to ask what's called the protected demographic information pertaining to race, sex, and ethnicity. We'll get into that in a few minutes. The covered credit transaction qualifiers that arise from a covered application, which is an oral or written request for covered credit transaction made in accordance with your institution's procedures for that type of credit. In other words, a business credit as defined in 102.2G, the primary purpose test, because people are asking questions about that. That does not include either evaluation, extension, or renewal, as I said before, and it doesn't involve inquiries or pre-qualification requests. So that's not a covered transaction. It's not a covered application. In a business, it does involve a business credit transaction as defined in 1002.104. That's not one of the 6 excluded transactions in paragraph B. And I'll reiterate because this is so important. Trade credit, under reportable transactions, insurance premium financing. We have a client I know that does a lot of insurance premium financing all over the country. They've been reporting it as small business loans. That will no longer be something that's collected under 1071 and therefore won't be monitored under CRA. None of you have to worry. You're not public utilities. We're not talking about making loans for securities, and we're not talking about incidental credit. And then there's those 4 other exclusions that are not explicitly in the rule, but are in the official instructions or interpretations. So the applicant, again, has got to be a small business as defined in the regulations. And you can see what the definition is here. Basically, if you go to Part 121 of the Small Business Administration regulation, that has all the sizes and the NAICS codes associated with small businesses. And at the end of this webinar today, we will announce that we have available a copy of the latest version of the Part 121 table, which has all the NAICS codes for all the small businesses. So to summarize, there's two issues you have to resolve. Is the application itself a covered application that is not excluded or exempt, as we were saying, and is the borrower a small business? So again, I'm going to go through these things. I'm being a little bit repetitious here because you've got to understand what these exceptions are and what's required. So the applicant must be a small business as defined in 106, which says same term as business concern in 121-105, which says business entity organized for profit and may be in the legal form of an individual proprietorship, partnership, limited liability company, corporation, joint venture, etc. The applicant has to initiate the request, and we're going to get into this in a few minutes. Again, the circumstances that are not covered cert applications that we enumerated or identified a few minutes ago, which are the reevaluation, extension, or renewal request on the existing business credit account, unless there's a requested increase in that amount, and inquiries and pre-qualification requests. So we're up to 4 of the 14 factors that you've got to be aware of. And then under 104B, the excluded transactions, you got trade credit, HMDA, insurance premium financing, public utilities credit, securities credit, and incidental credit. And then factoring is not counted. Leasing is not counted. Consumer designated credit is not counted. And purchase loans or purchase of a pool, an interest in a pool of loans, or purchase of a partial interest in a credit transaction, in other words, a loan participation, are not covered transactions. So when you got the applicant sitting in front of you, you have to figure out, well, what questions do I have to ask? What do I have to determine before I can go in and ask about the protected demographic information, which is really a hot topic, because if you ask it under the wrong circumstances, you're violating the law and the regulation. If you don't ask it under other circumstances, you're violating the law that way. So you've got to know, is this an excluded transaction or a not covered application in 103B? Is the applicant a small business that has initiated their credit request, or does the business applicant have $5 million or less in gross annual revenue? And then in the preamble, it's stated, the Bureau interprets 704B's introductory language and 704B1 to require, I underscored that, to require that a financial institution first straightforwardly assess whether an applicant is a small business before proceeding to inquire into the applicant's protected demographic information that would otherwise be prohibited by existing regulations. So it's a very sensitive topic. You got to be very sure of yourself, and that you're asking questions that you have to ask, or not asking questions that you're forbidden to ask. So again, what's a covered transaction? It meets the definition of business credit under Reg B with certain exceptions. And those exceptions I'll get into again down below for the third time. It must be initiated by the business borrower. Solicitations don't count, although you have to maintain records of any such outreach efforts. And it excludes, again, any request for a reevaluation, extension, or renewal of credit requests, unless it involves an increase in the credit available. It does not include inquiries or pre-qualifications. It does not include trade credit, insurance premium financing, public utility, securities, and HMDA mortgages, and incidental credit. And in that list, again, I think insurance premium financing is really, the thing that might affect some banks. Like I said, I have a client that does a lot of that, and they report it for CRA, and now it won't be involved. It does not include factoring. It does not include leasing or consumer designated credit. And again, I highlighted, it does not include loan participations, loans purchased, which are now allowed, or participations in a pool of loan. Only the originator reports. You don't get any credit if you purchase such a loan like you would get today under CRA. So, and again, I reiterate that when you're talking about a loan increase, it is reportable as a covered transaction if you're a covered institution. But if you're not a covered institution, it's not included in the transaction count when determining if an institution is a covered lender. So let's talk about inquiries and pre-qualification requests, because this could be kind of a fuzzy area, and these do not involve covered applications and covered transactions. So you want to make certain that you don't go and start asking about the protected demographic information for something like this. So an inquiry versus a request for credit. Solicitations, firm offers of credit, and other evaluations or offers initiated by the financial institution are not covered applications. So what is an inquiry? An inquiry is a request by a prospective applicant about credit terms offered by the institution. So somebody comes in and says to you or your commercial loan officer, does your institution extend SBA loans? Well, that's just an inquiry, and you can respond, yes, we do, or no, we don't. If you respond, yes, we do, then at that point in time, the business person might say, well, I would like to get an application for an SBA guaranteed loan. Now, basically the inquiry has been converted to an application because the business person is now asking for information, and beyond information, they're asking for an application to be eligible for a small business administration loan. A pre-qualification request is a request by a prospective applicant for a preliminary determination on whether they would likely qualify for credit under the lender's standards. So again, a business person comes in and let's just say that they're located a couple hundred miles away from the bank or the whatever office you're operating under. Your institution might have a rule or a policy that you lend only to businesses that are within a certain distance from your facilities. So you might say to that prospective applicant, well, I'm sorry, you're in Syracuse, New York. We're in New Haven, Connecticut. We don't process or requests or applications from people who live outside of Connecticut, for example. An applicant-initiated request for credit is a critical distinction. So some of these inquiries and pre-qualifications can go from an inquiry and pre-qualification into an applicant-initiated request, depending on how they respond to the information that you give them during their inquiry or the pre-qualification. So if the applicant responds to a solicitation or offer by requesting the offered credit, then their request becomes a covered application. And because this is so important, this is right out of the preamble. I just want to read it because I know this is something people could easily get confused. So pardon me while I just read this, but it's important to understand it. So an inquiry is a request by a prospective applicant for information about credit terms offered by the financial institution. A pre-qualification request is a request by a prospective applicant for a preliminary determination of whether the prospective applicant would likely qualify for credit under a financial institution's standards, or for a determination on the amount of credit for which the prospective applicant would likely qualify. Inquiries and pre-qualification requests are not applications under subpart B of this part, even though in certain circumstances, inquiries and pre-qualification requests may constitute applications under subpart A. For example, when an inquiry or pre-qualification request may become an application under subpart A if the creditor evaluates information about the business, decides to decline a request, and communicates this to the business, such inquiries or pre-qualifications would not be covered applications under subpart B of this request. Whether a particular request is a covered application or whether instead it is an inquiry or pre-qualification request that is not reportable under subpart B may turn, for instance, on how a financial institution structures and processes such requests. Does the financial institution require or encourage a preliminary review in order for a business to be considered for a covered credit transaction? Or does a business voluntarily seek preliminary feedback as a tool to explore its options before it decides whether to apply for credit with the financial institution? The name used by the financial institution for such a request is not determinative. For example, under subpart B, a review is a reportable covered application if the financial institution requires the business, before it may apply for credit, to pass through a mandatory screening process that considers particular information about the business and denies or turns away the business if it is ineligible or unlikely to qualify for credit. In contrast, a business that requests a financial institution to identify credit products for which the business might qualify based on limited or self-described characteristics and without any commitment from the financial institution to extend credit may not have submitted a covered application for purposes of subpart B. I hope that helps clarify things, but I'm certain there's going to be plenty of questions about that. So what we're recommending is you want to qualify if an application is covered by incorporating certain questions or requests in a preliminary application. So you want to determine if the transaction is an excluded transaction or a not covered transaction or a not a credit transaction as defined in a COA. So is the application disqualified as covered under Section 1071 because of any of the 14 reasons that I cited in several slides? If the transaction does not qualify, just stop. You don't have to go any farther. This is not a 1071 transaction. You don't have to get into all the protected demographic information. However, if it is not disqualified, you have to proceed. And what you have to do is you then have to determine whether this is a business request, a small business request. So when you develop data collection procedures for business credit requests, you should incorporate a clear statement about qualifying an applicant as a small business immediately before processing any request and before asking any question, definitely about the applicant's protected demographic information. And it's always advisable to have this all documented in writing. So really at the top of the first page of any potential credit application, you should have some kind of a question regarding the gross annual revenues of the business or whether the business owners or principals that are sitting before you will give you a statement indicating, yes, our business does $5 million of gross annual revenue or less. Remember, you got to qualify two things, whether it's a covered application and whether the borrower qualifies as a small business. You're at great risk if you don't do that because you may not ask the questions you're mandated to under 1071, or you may ask questions that you shouldn't be asking if you don't get this thing right. So over and over again, I'm focusing on this very first part of what you've got to do. Now, are you a covered lender? Well, you must originate at least 100 covered small business loans in each of the 2 previous calendar years. Now, this becomes fully effective in January of 2026. Covered, there's some compliance state tiers I'm going to talk about. Covered lenders are determined annually. So a covered lender may become an exempt lender if it does not meet the minimum number of qualified originations in any year. So you wouldn't become a covered lender in the very following year. So just like you become a covered lender after you've had 2 consecutive years where you're over 100 qualified applications or originations, I should say, the impact is immediate. On January 1st, you either become a covered lender and have to begin the data collection process for covered applications, or you are no longer a covered lender and you're no longer obliged to do that. Now, the CFPB is phasing in 1071 by mandating certain lenders become covered lenders based on their 2022 and 2023 covered origination volumes. There's 3 tiers. Tier 1 is for lenders who have 2,500 or more covered originations in both 2022 in each year in 2023. And if you are such a lender in tier 1, you have to begin data collection on October 1st of 2024, about 16 months from now, 17 months from now, and you would be reporting that data in June of 2025. If you are a tier 2 lender, where you have at least 500 originations in each of 2 consecutive years, but less than 2,500 in 2022 and 2023, you can begin collection. You must begin, not can. You must begin collection on April 1st, April Fool's Day of all days, in 2025, and you'll be reporting that information the following year in June of 2026. And then the tier 3 are the lenders that have done at least 100 covered originations in 2024 and 2025. They begin data collection on January 1st of 2026 and report that information in 2027. So 2026 is the year all covered lenders are to collect covered loan data. The compliance state tiers are now passed, and everybody that's the big lenders has already been collecting data and reporting. The smaller lenders, everybody's got to be on board and collecting the data at the beginning of 2026. No matter what your size, as long as you're doing 100 covered transactions and originations in the previous year. So how do you determine this? Well, for the compliance tiers, so what we want to just look at this. So basically, the Bureau is saying that, number one, you can go back into all your commercial loan activity in 2022 and 2023. You review all the business loans that you originated and determine which of those qualified as a covered transaction. Meaning what? Meaning that basically they didn't have one of those exclusions that we just cited, and that they were extended to a small business. So you can go back and basically audit your records, and based on that, you could just say, okay, we qualify as a tier 1 or tier 2 or whatever. Or they offer you an alternative. During October 1st of 2023 through December 31st of 2023, that's right, this year, okay, lenders can ask all business applicants prior to closing an approved transaction to self-report their gross annual revenue. So this data can be used to determine the annualized volume of qualified originations by multiplying it 4 times. So let's say you decide your institution's somehow caught in the middle. We're trying to figure out which tier we fall into, and we don't want to go back and just reconstruct all the credit activity we had for all of 2022 and 23. So let's take a look at the fourth quarter of 2023, and let's use that as a way of approximating what our annualized volume is. And so if you process, let's just say, for example, and close 150 qualified or covered transactions in the fourth quarter of this year, you can multiply that by 4 times, and that would be the equivalent of your annualized volume. So if you did 150, like I said, that means your annualized volume would be 600 covered loan originations. That means you fall into tier 2. Or conversely, if you did, let's say you did 700 such transactions in the fourth quarter, you multiply that 4 times. And if you did 700 covered transactions in the fourth quarter, covered originations in the fourth quarter, 4 times that would be 2,800. You would be in the first tier as far as the phase-in is concerned, the compliance date transition. Or you can assume that all business originations during 2022 and 23 were covered loans, and that'll be acceptable as well. And you can use that as the basis. And finally, the Bureau does offer you other reasonable methodology that you must document in writing to determine which compliance date tier you may fall into. But remember, you got to document what it is, and you got to put it in writing. Now, there is a grace period that they announced. And when I first looked at it, I said, oh, it's a grace period. Maybe you can delay for another year. No. You're going to have to continue to report as soon as you become a covered lender, but they will be more forgiving, if you will, if you make mistakes. So with respect to institutions subject to the Bureau's supervisory or enforcement jurisdiction, the Bureau intends to provide a 12-month grace period for the initial data submission from a covered financial institution that have compliance dates specified in, blah, 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 the tier 1, tier 2, and tier 3 institutions. Covered financial institutions subject to the regulation that must start collecting data on January 1st of 2026, and any financial institutions that make voluntary submission for the first time data collected in 25 or 26. The Bureau believes that the use of its discretion providing a grace period that covers 12 months for each tier may result in more deliberate and thoughtful compliance with the rule, while still providing important data regarding small business lending as soon as feasibly possible. So during the grace period, if the Bureau identifies errors in a financial institution's initial data submission, the Bureau does not intend to require data resubmission unless the data errors are material. So they're giving people a little more leeway. For the first time they have to file the data. That's what they call the grace period. And it'll just be for that first year that you're reporting you're a covered lender. And after that, this no longer applies. So start a data collection system now to determine the covered status, whether you're covered or not, in the future. And all institutions engaged in commercial lending with at least 100 annual originations need to have a 1071 qualification system, which is something I mentioned a few slides ago. So if you're not a covered institution, and right now today, nobody's a covered lender because the compliance dates haven't been put into effect, you need a system to collect the qualifications of potential Section 1071, quote, covered transactions. The system must determine if the credit type is covered or excluded or disqualified. You must determine the gross annual revenues of the business loans that are originated that are for a qualified type of credit. Again, meaning it's not excluded. So you do not need, and you should not ask for the protected demographic information at this point in time. You're trying to qualify whether the transaction is a qualified application or not. It's only after you determine if it's a covered transaction that you can ask the protected demographic information. So based on the foregoing records, you can determine if you're a covered lender. The transition rules require lenders to look back, as I was saying, to 2022 and 2023 to see if they pass the loan volume thresholds pertinent to triggering covered institution status. And again, the option this year in the fourth quarter, you can just use the data, the loans that you originate, the commercial loans that you originate in the fourth quarter this year, and you can annualize that volume if they're from a small business applicant or not. And then that'll become the basis for qualifying which tier you fall into. Or again, you can use any other reasonable method to ascertain as long as it's put in writing. I should have put that in the bullet point because it's got to be in writing if you're going to choose some other method. So what is protected demographic information? This is dynamite because this is stuff that you cannot ask for ordinarily. And so if you ask for it under inappropriate circumstances, you're violating a COA. And if you fail to ask for it under 1071 and you're supposed to be asking for it, you can get into trouble that way. So what we're talking about is the applicant is a minority-owned business or a woman-owned business or an LGBTQ plus owned business. And we're talking about the race, ethnicity, and sex of the applicant's principal owners. You cannot ask these questions if the applicant is not a covered application from a small business. So you've got to determine that. I know I've said this probably for the 10th time, but you have to determine if it's a covered application from a small business. The protected demographic information itself does not apply to guarantors. It applies only to the principals as defined in the rule and the business status, whether it's, again, a minority-owned business or women-owned business or LGBTQ-owned business. So the final rule says that the data can be reported based only on the information provided by the applicant. No visual observations allowed to be collected and reported, and you cannot verify the answers to the protected demographic information. You have to accept whatever the business applicant provides to you. And so even though you might be inclined to say, well, I want to verify this, you cannot. That would be violating the regulation. So do not attempt to verify. Of course, get everything in writing from the applicant, so you've got a record of what they've said and have them sign any application form. So you now know if you're a covered institution, you know what a covered transaction is, a covered application. So now you're in the situation, well, what do we have to collect? Okay, well, I'm just going to hit, there's up to 81 fields of data points that you've got to collect. And I'm not going to go over all 81 fields and get into them in depth, but I'm going to kind of cover the more important ones or the ones that are more common that might be people are going to ask questions about. So regarding geocoding, there's what they call the waterfall. The first thing is the preferred way is to geocode the loan to where the proceeds will be primarily used. The second alternative is to the main office of the borrower, wherever that is located. Or if you don't have the first or the second one location, then some other location. Now, it's hard for me to imagine if you're going to be making loans to people you don't know where they are. I can't imagine what circumstances that would be. You might have some safety and soundness problems if you're doing that. But this is the geocoding method. And by the way, there's a safe harbor. If you use the geocoding engine on the Bureau's website, and there ends up being some geocoding errors, you have a safe harbor because you're using their official geocoding engine. So those of you that are using software provided by certain vendors, you might want to ask them if they have an API between themselves and the Bureau's website and the geocoding engine on the website, so that you know that you're using the Bureau's data for geocoding purposes. You're supposed to collect the gross annual revenue for the preceding fiscal year. However, there's an option that says not provided. So theoretically, you could be making a loan to a business that you qualified as small because they told you that they don't do $5 million a year or more than $5 million a year of gross annual revenue. And but you didn't get the details. So you don't have the actual GAR. All you have is a representation from the borrower. Again, this maybe is not the safest, soundest way to practice lending, but theoretically, as long as they gave you an answer that they do $5 million a year or less of sales, then that becomes a small business. Only the applicant can provide the protected demographic information. You can verify some of the other stuff that they're submitting, like the financial statements, et cetera. So you need a reasonably designed applicant provided data form. The initial information request must be made before the final decision. This is what they consider to be the parameters of a reasonably designated applicant provider data policy or approach. So you've got to get the initial information before the final decision is made. But of course, after you've qualified whether it's a small business loan for a covered transaction, the request for the applicant provided data is prominently displayed, and the collection is done in a way that doesn't discourage an applicant. Now, this is interesting. An affiliate's gross annual revenue may be included, but there's no requirement to include it in the JR. So that's going to be up to you. And whether, first of all, there is an affiliate, and if the applicant gives you that information, but you're not obliged to collect that data and report it. Non-affiliate gross annual revenues are not to be included at all under any circumstances. If there's multiple unaffiliated applicants, only the first small business listed on the application is what you're talking about. And you may use previously collected data if it was collected within 36 months of the application, except for the gross annual revenue information, which must be collected in the same calendar year as the application. And you have to retain these records for 3 years after the loan register is required to be submitted, which is going to be June 1st of each year after you've collected the data. Okay, reevaluation, extension, and renewal requests that do not request additional amounts are not covered, but if additional credit is requested, a renewal is a covered transaction, but only the new money is reported. A refinancing occurs when an existing obligation is satisfied and replaced by a new obligation. It's pretty much the same definition as under CRA, but the renewal is different from CRA, as I was explaining before, because a renewal under CRA could involve the entire amount of money. It does not necessarily have to have new money involved, but it does mean under CRA, a renewal means that you have to extend the maturity date of the note underlying the transaction. If you do that, that would be a reportable renewal under CRA, but it would not be under 1071. Okay, some more details to talk about. So again, what they call the Small Business Lending Application Register has as many as 81 data points or fields versus 16 currently. So you're talking about quintuple, 5 times the number of fields of data to be reported versus what CRA requires. So those of you that were like, oh, CRA is pain in the neck and all this, well, it's going to be a piece of cake compared to what 1071 is. Now, this is also interesting. Again, the action taken, because unlike CRA, you're reporting only loans that you originate and loans that you purchase, right? So there's only action code 1 and action code 6 under CRA today. Under 1071, the action codes are just like they are under HMDA: originated, approved, not accepted, denied, withdrawn, and incomplete. However, there is no action code 6. You are not going to collect and report data on loans that you purchased. So there's going to be no information about that in the aggregate and disclosure data. 14 of the 81 fields pertain to pricing information, and 36 of them pertain to race and ethnicity of the principal owners. It's interesting that, again, you can answer for the gross annual revenue not provided, even though you're supposed to be qualifying the business as a small business based on gross annual revenue. And I asked one of the CFPB lawyers about that, and they told me, well, all you need is a statement just from the business applicant saying that we do $5 million a year or less of gross annual revenue, and that's sufficient to trigger it being a covered transaction. You don't need the actual gross annual revenue. So that's interesting. You have to collect the time in business, the credit type, the term of the loan, the lines of credit, credit cards, etc., the credit purpose, and up to 3 different types or use of proceeds, 3 purposes. There's going to be information about loans that are guaranteed, the nature of those guarantees. You're going to have to collect the NAICS code. It's a 3-character code, not the full NAICS code, but that still means so you're going to need that Part 121 book that we are going to provide to today's registrants for free. It'll be available on our website. You'll get an email tomorrow instructing you how to recover that book. You're going to have to collect information about the number of employees by the business. So this is something that's never happened before. I'm going to tell you, I'm going to give you an educated guess why I think they're doing that. I think they're doing that because the Dun & Bradstreet data, which has been used for determining business size, in my opinion, has always been suspect, and it's never been transparent. Effectively, it gave a monopoly to a private entity on a critical piece of data, etc. Now, there happens to be an alternative database that's a public database that's available. It's called the Census County Business Patterns, and it's fantastic. It's got incredible detail in it. It's got the NAICS codes and information about the size of businesses everywhere in the country by zip code, okay? The problem right now is that is based on the number of employees. So the Census County Business Patterns fabulous database does not tell you the gross annual revenues of different businesses. It tells you the number of employees. I suspect, I might be wrong, but I suspect that's one reason why this is being requested. It might become the substitute for gross annual revenue under CRA. They might start defining small business loans, truly small business loans, as those to entities that have whatever, 10 or fewer employees or whatever the interval is. You're going to have to report the denial reasons, just like you do under HMDA, by the way, too. Now, you have to provide a form or a process that is going to encourage the applicant to give you the information. And it's got to be what they call reasonably designed procedures. And there's 4 characteristics of reasonably defined procedures. First of all, the initial request for the applicant provided data, in other words, protected demographic information, occurs prior to notifying the applicant of a final decision. You can't ask them after the fact. The request has got to be prominently displayed on some form or somewhere where the applicant can see it. The collection does not have the effect of discouraging the applicant. So you got to be very careful with the wording. And the 4th characteristic is the applicant can easily respond to a request for the applicant provided information. That's right out of the preamble. And so you've got to make certain that whatever forms you design to get the applicant provided data, they conform with these 4 standards. So protected demographic information, the business principles, can be provided only by the applicant. Again, no visual observations are allowed to be collected and or reported. Even if the applicant says, I'm not telling you, you can't then put down, well, we visually observed it pertains to ethnicity, race, and sex. And during the transition period, an institution that will be covered is permitted but not required to collect protected demographic information beginning 12 months before or prior to its applicable compliance date. So if you're one of the large lenders who will have to start collecting data on October 1st of 2024, theoretically, you could commence collecting the data, the protected demographic data, if you have yourself set up you could start collecting that on October 1st of 2023, but you won't be required to. Now, this is interesting, and this is another area that could be confusing. So what is the definition of a minority or woman-owned or LGBTQ-owned business? Well, there's two conditions. One is that 50% of the of the ownership or control, and I'm sorry, I should say more than 50% of the ownership or control, and 50% or more of the profits go to such individuals or entities that are controlled by them. The principal owner definition is that a person must own 25% or more of the company, the entity, that to be qualified as a principal person. Now, this is really interesting, and this is where you got to listen carefully. A minority or woman-owned or LGBTQ-owned business may have no principal owners who qualify as minorities, women, or LGBTQ individuals. What? How is that possible? Isn't it supposed to be ownership, 50% or more ownership? Well, the key word is control, number one, because they define control as being in an executive position where you're managing the business. That's a substitute for ownership. The one thing it's not clear as well, and they enumerate, by the way, in the regulation, that not only you're talking about a president or some kind of chief executive officer, they mention vice presidents, et cetera. So I've submitted a question to the Bureau to ask them, well, how much control, how do you measure control? If somebody's the vice president of a company versus the president of a company, are you saying that the vice president, one person in that position, constitutes control? Because it's not clear in the rule, not clear in the preamble, and not clear in the official interpretations of the rule. So this is why you can. And by the way, another thing is this: if you have 10 people and they're all whatever minorities or they're women or whatever, obviously there's no principal owner in that situation, because a principal owner by definition has to own 25% or more of the business entity. So you could have a women-owned business that is 100% owned by women, but there is no principal owner in the business, because by definition, under the rule, a principal owner is someone who owns 25% or more. So in that situation, you wouldn't have to collect anything regarding the principal's race, ethnicity, or sex, because there is no principal. But you would still have to determine if it's a woman-owned or minority-owned or LGBTQ-owned business, and that is what you have to ask the business representative that's in front of you. Do you qualify as a woman-owned, minority-owned, or LGBTQ-owned business? And you can provide them with some information about what the definition is, but you are subject to the way they answer it. You cannot verify it. It's simply, you have to accept what they tell you. So if somebody's sitting in front of you with an application for a covered application, and you're asking them, you've gotten through, you know it's a covered transaction, and it's a covered application that was requested by a small business. So now you're trying to find out the protected demographic information. And the first thing you're going to ask is this a minority-owned business? Is it a woman-owned business? Is it an LGBTQ-owned business? And they're going to tell you, yes, we are LGBTQ, or we're female-owned, or we're minority-owned, and you accept that. That is it. You not only have no responsibility to verify it, you are not supposed to try to verify it. So there can be actually situations where you have a minority-owned business where there's not a single minority principal owner. And so just don't think that, that the principal owners have to be majority, minority, or female, or LGBTQ. The firewall, that's a question that's been coming up from a lot of people. So generally, an employee or officer of a financial institution or affiliate involved in making a determination regarding a covered application is prohibited from accessing the applicant's responses about the protected demographic information. But the prohibition is waived if the financial institutions, it's not feasible prohibit an employee or director involved in the credit decision-making process having access to the protected demographic information, and the financial institution provides notice to the applicant regarding that access is available to certain people involved in the credit decision process. It's very likely to apply to small organizations and community banks, for example, because everybody knows everybody in the community. And by the way, this applies to specific people. So if there's people involved in the decision-making process that are going to have access to the protected demographic information, they should be cited specifically in a policy and procedures document that you develop to say what your institution's policies and procedures are going to be, and identifying individuals that are going to have access through the firewall and why they're allowed to do it, why it's not feasible not to let them have access. And one little note I would suggest is whatever you do in that policy and procedures document, it would be highly advisable, in my opinion, to put in some statement to the effect that anyone in the credit decision-making process who does have access to the protected demographic information shall not disclose that information to anyone else involved in the process. Because once they sit in a credit committee and they say, oh, so-and-so, blah, 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 well, you've just broken the firewall, not just for them. And it might be appropriate to break it for them, but then everybody else that's in the credit decision-making process has just heard something they're not supposed to hear. And if you haven't carved out an exception for them, that could be grounds for a lot of problems. So incorporate a statement into policies and procedures regarding limited access to the protected demographic information. And if the financial institution determines, quote, that an employee or officer should have access to an applicant's responses regarding the applicant's protected demographic information, explain what the underlying rationale is. Don't assume it's self-evident or obvious. And you have to give a notice to the applicant if access to the protected demographic information will be granted to persons in the decision-making process, and then make it a written policy and practice that the credit decision makers who know the PDI are instructed not to disclose it to any other credit decision maker, which I was just saying. Okay. Now, when you make mistakes when reporting, aside from I mentioned to you the grace period, which they were talking about, there are certain safe harbor provisions that have been put into the rule. Okay. And what they're going to do is they're going to give you a limited latitude in terms of errors predicated on a sampling and the errors found in that sampling. And I'm going to show you the table in a minute. So what they're going to do is they're saying that errors are going to, and the acceptable error level will be based on a sampling of records extracted from the small business lending application register and based on its size. And we're going to go over that in a minute. The random sample size determined by the number of records in the lending application register. So the more loans you do, the larger the random sample gets. The fewer loans you do, the smaller it gets. And again, in a few seconds, I'll show you the table. The acceptable unintentional error threshold is determined by random sample size. Again, it's going to be in the table. I'm going to show you in a second. The acceptable or unintentional error rate is based on sample size, which I just said. The error threshold applies to a single field. So it's possible to have many more errors in other fields as long as no field has more than 3 or 4 errors, depending on what the sample size is, which we're going to look at in a minute. There was nothing I could find in the rule or the preamble or in the official interpretation regarding the resubmission of incorrect data and where if there's a threshold of so many percentage of so many records. I've submitted a request to the CFPB regarding that matter, and when I get my responses from the CFPB, I will share them with people who are interested. And by the way, I will compliment the CFPB in this sense. I've submitted a number of questions to them, and the response has been really good. They have responded to the questions I've asked them, usually within 2 or 3 business days, and it's with a personal phone call from a lawyer from the CFPB. And they've been very engaged and willing to suffer my badgering them and asking them a lot of questions, and they've been a very big help. So I would compliment the CFPB for that effort. And so you shouldn't be intimidated either. Submit questions to the CFPB. There's a line that you can submit it to, a page on the CFPB website, and it's for inquiries like for questions. Here's the table. So if you are a small lender and you're doing 100 to 130 basically applications per year, the random sample size is going to be 47 records, and the threshold is 3 errors per field. Again, you might have 81 fields, so technically there could be quite a few errors, but no more than 3 per field. And you can see if you go to the larger size, if you're doing, like 100,000 or even 500 or more, the largest number of errors that they will find acceptable in any given field will be only 4 errors. And of course, the random sample size you could see is at the max is 159 records. So you yourself might want to, when as part of your internal procedures, is do random samplings periodically and have somebody verify the information and see what kind of error rate you come up with and whether you're exceeding the threshold. You'll know if you're in the safe harbor area or not. The old renewal problem. Under CRA, a small business loan, a small farm that is renewed is reported. Under 1071, renewals are not reported unless there is an increase in the loan amount, and then only the increase is reported. So there's a very big difference on renewals between CRA and 1071. Okay, this means millions of credit facilities will not be covered, resulting in a big understatement of the need for small business credit. I'm referring to revolving lines of credit that are secured revolving lines of credit secured by business assets. It's prudent for lenders engaged in asset-based financing to take UCC filings and to and basically use a demand note so that the continuity of the security interest is not interrupted by every time you issue a note. If it's a new note, the perfection process restarts again, and anybody that jumps in between when you write the new note or before you write the new note will have a lien position on the business assets that will supersede your institutions. So that means that you will lose a priority. And so it's a safety and soundness issue, and you got to be very careful. And so millions, in my opinion, of transactions or facilities like this are not going to be reported. And I believe that's a big mistake because that's the kind of credit facility that's common and used by many, many, many businesses. Okay, some potentially confusing issues. The business does not have to be owned by a majority of qualified principal owners. So you could have a situation where there's a single minority principal owner and it still is qualified as a minority owned business, like I explained a few minutes ago. That sounds confusing. Well, that's the deal. The status of the business as a minority owned, et cetera, is determined entirely by the applicant. You have no say in it at all. You might develop some kind of a form that gives them, explains to them what the definition is, but it's still going to be their answer that prevails. And now with the history of a small business loan being defined as $1 million in loan size for CRA purposes, lots of lenders are going to get confused and think the new $5 million gross annual revenue concept is the same thing as the loan size, but it's not. We've gotten a lot of questions from people saying, well, what is the limit? And you know what the answer is? There's no limit to the size of a small business loan. It's really a big change from CRA. The limit is got to do with the gross annual revenue of the borrower. So if you're lending to a company that's got, let's say, $4 million of gross annual revenue, and they're building a $30 million new manufacturing facility, if it's a covered application from them, they'd be a small business, that would be a reportable transaction under 1071. One loan could be $20, $30 million. Unlike CRA, where the max is $1 million. There will be no regulatory limit to the size of the business loan. So as I just said, well, what if the applicant says the gross annual revenue is less than $5 million, but you do get financial statements which contradict that? That's one of the things that you could verify. You can't verify the protected demographic information. So if you get something that contradicts it, you're allowed to change the status of the application from being, in this case, a covered transaction to one that's not covered, or it could be the other way around. you started processing an application, you get the financial statements, and all of a sudden you realize, wow, we thought this business was a lot bigger, but it's really, it's going to be a small business as defined in the regulation. So now we got to go in and we got to get the protected demographic information. What about the affiliate gross annual revenues? They're totally voluntary. If you want to get them and report them, you can, but you're not mandated to. It's only the gross annual revenue of the borrower. If you can get it, that's mandatory. There's going to be potential confusion regarding renewals or refinancings, as we just said. If you're not a covered lender and you originate small business loans, you will still need to collect data that identifies any small business loans you originate to determine if you will become a covered lender. So again, I said that 5 times already, probably. If you don't think you're going to be a covered lender, you can maybe breathe a sigh of relief for a while, but you can't give up monitoring your situation if you're engaged in any kind of commercial lending volume at all. I mean, if you don't do commercial loans, well, that's another story. But if you're doing something like 80 or 90 commercial loans now, who knows? In a couple more years, you might be over the 100 level, and all of a sudden you're a covered lender. And if you're not monitoring and watching that, you could inadvertently be violating the regulation by becoming a covered lender, but you don't report and collect the data because you don't realize it. So the only way you can get free of Section 1071 is to stop making commercial loans. I'm not going to recommend that. So what are the implications for the Community Reinvestment Act? Well, the small business definition is changed radically, not just substantially, but radically. It's no longer based on the loan size. It's based on the gross annual revenues. So there's going to be lots of transactions that were not reported as small business loans before that will be reported now, and the loans will be bigger. Okay, the gross annual revenue $5 million cap is going to be adjusted every 5 years. The first time it'll be adjusted will be effective January 1st of 2031. It'll be in $500,000 increments, basically. So maybe it'll go to $5.5 million, maybe it'll go to $6 million 5 years from now. Who knows? With inflation going like it is, maybe it'll be $8 million. But it'll change every 5 years after it's initiated. All right, the borrower characteristics test, which is now based on gross annual revenue, may switch to the number of employees. Like I said a few moments ago when I was talking about that question, that data field that you got to collect this information. Much more information about the business borrowers. You never had to get information about employee counts, the NAICS code, how many years in business. All the stuff is going to be required. Information about the principal owners has never been collected and reported as part of CRA, but it's going to be collected and reported under 1071. There's going to be a lot of details about loan pricing, the loan type, the loan term. Say up to 81 fields in the small business loan register. And of course, the course of action will change dramatically because no loans purchased are going to be reported anymore. They're an excluded transaction. And I'm wondering, will denials ever become a factor for CRA purposes? That information was never collected, has never been collected, but now it's going to be collected. I wonder if it's going to become a factor in CRA exams. Okay, so the implications for CRA, there's going to be many, many new bank lenders, because if you were under, right now, the threshold's $1,503 million, I think is where it is right now. But that's going to be irrelevant. It's going to be based on how many transactions you do. And I'm certain there's a lot of banks that are less than $1.5 billion that are doing 100 or more small business loans. They're going to be mandated reporters under 1071. Many non-bank lenders are going to report. The credit unions, commercial loans, lending companies, et cetera. As long as you do that covered transaction threshold, you're going to become a reporter. The preamble actually estimated that about 2,500 covered lenders will be reporting under 1071 versus 600 roughly under CRA. So it's quadruple the number of reporters. That means a lot more loans are going to be reported. And of course, there's going to be a lot more loans reported because of the definition of small business being changed radically. There's going to be no size limit to the loan. So the dollar value of CRA small business lending activity is going to be increased exponentially. This is big. How will the phase-in, the tiered compliance states, affect the publication and availability of the valuable performance context, aggregate, and disclosure data? Are the regulators going to require the banks that are in tier 1 and tier 2 to continue reporting under CRA until 2026, when everybody will report, that's a covered reporter or covered lender, will be reporting under 1071. So what's going to happen? We know that the largest lenders are going to be reporting 1 quarter's worth of data in 2024. The next tier, tier 2, is going to report 3 quarters worth of data in 2025. So what good is it going to do to have just some of the information, but not all the information? My gut is that the agencies are going to insist that the CRA reporting, large banks will continue to report until 2026, when the reporting for everybody who's a covered lender under 1071 will be mandated to report. But I don't know. To me, all this data is going to be collected. It's not going to be worth anything if it's just for some lenders for just part of the year. So I believe there's going to be no choice, but that's an educated guess. I think you're going to see that the reporters are going to, the mandated reporters right now, the large banks, are going to continue reporting. So how will the agencies react to the gradual release of data containing that only some lenders are going to report data for only some years or part of the years of activity? That's a guess. I can't believe you need that performance context data. So, and it can't be halfway. It's got to be all or nothing. You can't be, as they say, half pregnant. You either are or you aren't. And in this case, basically, I think the agencies are going to require the large banks to continue reporting under CRA until all the mandated reporters start reporting in 2020. Start collecting, I should say. They start collecting on January 1st of 2026 and reporting the following year in 2027. Okay, so those are the issues I'm raising. And what about the publication of the 1071 data and how it might affect the CRA performance tests and standards? One thing I think is a strong possibility is what they call the borrower characteristics test number 4, which right now is based on gross annual revenues being $1 million or less for a small business and $1 million or less too for a small farm. Will they change that to the employee counts and start using the Census County Business Patterns database for the demographic data? And the last point here, I thought about this earlier today, actually, as I was reflecting on this. Will the big increase in the size of business loans result in fewer reported community development loans? Now, think about this. Right now, any loan that's a business loan that's over $1 million is not a small business loan. So it's got community development characteristics. It can be reported and claimed for community development credit. But now, if small business loans could be $5 million, $10 million, well, that means those loans that were heretofore qualified as community development loans because the borrower was not a small business under the current definition, all of a sudden that will be a small business loan, and that means those loans could be disqualified for a community development credit. So again, I'm saying some things a little redundantly simply because I think these are the big issues. The publication of the aggregate and disclosure data, I think, is a big complication and a big mess for a couple years. The Bureau itself does not anticipate making a determination of what data and what format the reported applications will be published in until after it receives the first tranche of such data. So what does that mean? Even when the Bureau gets the data, are they going to delay releasing it for a couple of years while they try to figure out what's sensitive and what they want to protect? So the complete aggregate and disclosure data may not be available until under 1071, may not be available until 2027 or even later. And again, what will the prudential regulators do regarding mandatory reporting? And since the first time all recovered lenders will be mandated to collect data will be for the calendar year 2026, and that data will not be available until late in 2027, what will the regulators do for CRA exams during 2027 that will include the 2026 and previous years? That, in my opinion, is a big problem. Getting near the end here, hopefully. So what are the most likely common misunderstandings? The very first thing is I was talking to the chief risk officer of a decent sized bank a week ago, and we were talking about 1071. And basically, I said to her, what do you think? You're going to be in tier 1 or tier 2 or what? She said, oh, we did like 2,000 small business loans that we reported for CRA last year. So we're going to be in tier 2. I said, whoa, wait a minute. You're talking about what you report in small business loans, but for 1071, it's different. You could have many more loans for 1071 that would not be CRA reportable. So that what you did last year may be kind of a basis or a foundation, but my guess is you did a lot of commercial loans that would have been qualified as covered transactions, and therefore the small business loan activity you reported under CRA actually may not be an accurate indicator. It may substantially understate what your covered transactions will be, which will trigger you being a covered institution. And this is the updated Part 121 size standards. This is the booklet we got from the SBA. We downloaded it. It's got pages and pages and pages of all the reported SIC codes, I should say the NAICS codes, and the size of the businesses, et cetera. You want to have this available for your NAICS codes and to make certain the business is qualified as a small business. And let me see. So a couple of quick questions, and maybe Glenn, Dean, you've got some from, I know that we got before. So do the principal owners of a minority-owned business need to be minorities? No, because remember, there may be no principal owners. Everybody might be 10% owner, and therefore they're not a principal owner defined in the regulation. Is the maximum size of a small business loan under 1071 $5 million? Nope, it's unlimited. Okay, name 3 types of transactions that are excluded transactions. Gee, I wish we should have done a poll for this, Dean, I think, So any loans that are purchased, any participations, and any rules that are not increased, there's three of the 10 excluded transactions. So I'll ask everybody that's listening today, test yourself and see if you can remember the other excluded transactions. Are renewals reported under 1071? Only if there's an increase, and it's only the amount of the increase. And are refinancings reported under 1071? Yes, that's true. Dean, you've got some questions. We've got a few minutes left. Go for it.
Well, Len, we do. I was going to say we don't have enough time to address all of them. We got well over 40 some odd questions that came through, and I've done my best to try to segregate them. Some of them were duplicated, and so let me fire away with just a few that seem to be kind of a common thread. So I know we're limited on time. I'm not sure how you would like to address the rest of these, whether we download them, respond, and then upload them so that they're available on a website. Yeah, we're never going to get through all of these.
Okay, well, we'll try. Maybe ask me a few yes or no's or something. I don't know. But
well, here we go. Let's start off with the first one, and then the first one is has been it doesn't matter how it was submitted, but does 1071 replace collecting small business data under CRA, or will we now be collecting under the 2 rules?
That's a great question, and I did mention it, but we don't know for sure. We know eventually 1071 is going to replace all small business reporting under CRA, not community development reporting, but small business and also small farm lending, because that's going to be reported under 1071. But during the transition period, when people are phasing in, my gut is that the agencies are going to ask the CRA reporting banks to continue reporting, because they're just going to have incomplete data for aggregate and disclosure purposes, which is going to seriously handicap the ability to conduct a CRA examination and look at the benchmarks. You can't do it. So that's my thinking. I think there'll be 2 years in which the large banks are going to have to report while they're also collecting and reporting under 1071. And then for 2027 will be the first year when 1071 small business loans will replace the CRA small business loans.
Okay, so this somewhat dovetails into that. You said that CD loans will still be evaluated under CRA and not 1071. Right. Today, however, there's a prohibition on reporting loans as CD if they already included on the small business law. If loans are 1071 reportable, will they be eligible to be considered for CD credit?
Well, that is one of the things that we're going to have to see what the prudential regulators say. But keep in mind, we don't know what the data is going to look like. As I speculated in my presentation, there's going to be many, many loans that are much larger than ever before reported under CRA. And so all those loans that under CRA up until now that were, quote, small business loans, but also qualified as community development loans, well, the loans over $1 million, bingo, okay, we got a community development loan. Now, because the prudential regulators have said 1071's definition of small business is going to prevail, I suspect that it's going to substantially impact and reduce the amount of community development lending unless the prudential regulators say, you know what, we're going to allow, just like we do for multifamily affordable housing, we're going to allow double counting of some of these loans. That might be an outcome, but all I can do is speculate.
To determine the size of a small business, do they include the entire relationship or just the information for the individual loan?
Well, the loan is the loan. Yeah. It's the size of the business measured by gross annual revenue. So it doesn't matter if you had 20 loans with this lender, one loan, it's going to be based on the gross annual revenue at the time of the transaction, of the application, the latest fiscal, not calendar year, by the way, the fiscal year end statement for the borrower. So, I'm not quite certain what they mean by, what was the phrase they use about the entire relationship or something. It's the size of the business, period. Size of the business, the gross annual revenue. That's it. That's all you have to know.
If you're a HMDA reporter, you also need to determine almost immediately if the application is a HMDA reportable application or an application for 1071. So do you know what to collect for demographic data from the applicant?
All right. So there's the PDI, the protected demographic information. Number one is going to be pertinent to the business itself, not a person, but to the business. Are you a minority-owned business or not? Or are you a women-owned or LGBTQ? So that is going to be pertinent to the business itself, and it's what they call its status. Okay, the race, ethnicity, and sex questions pertain to principals in the business. Now, again, as I said, you could have principals that are all white and still have a minority business because of the control thing, or you could have a minority-owned business with 10 people, each a minority person owning 100% of the business, 10% each. So there's no principals to ask the protected demographic information. So the PDI refers to the status of the business and is up to as many as 4 principal owners, if there are 4 principal owners. And that's it. It's got nothing to do with guarantors. Guarantors, no, you don't ask that, for example. It's strictly only the business itself and its status and the race, ethnicity, and sex of principals, which are defined as owners of 25% or more of the business.
Okay, perhaps I missed something, but on this one, it says, where are you getting that this is applicable to CRA? In the NPR that was released last year, the prudential regulators said that they're going to use the $5 million, which is what they were anticipating was going to be, and they're going to defer the data collection to 1071 once it's completely phased in. So the prudential regulators themselves said that. Fantastic. And I think we have time for perhaps one more. We as a CDFI do use demographic data when making credit decisions with the goal of promoting minority-owned businesses. Do we have to stop making credit decisions based on this data?
No, I don't see it prohibiting that at all. It's mandating that that all commercial lenders who will become covered lenders have to collect this information for a covered application. I don't see it affecting CDFI's, what they're able to do right now as a CDFI, collecting information regarding, businesses that they're lending money to and supporting. So I don't believe it's going to have any impact. Now, a CDFI would be required to collect and report under 1071 if it's a covered lender. So they're going to have to collect that information under 1071 for sure.
Fantastic. Well, like I said, Len, we have numerous questions, so I think probably the best thing, and we are out of time. So
maybe we're out
I
of
think
town
perhaps
too.
we'll try to condense these, consolidate these, and get rid of the repetitive questions, and respond to them and post them along with the presentation.
Great. Well, I hope people got a lot out of it. I can tell you this, every time I've read it many times, the preamble, the rule, and the official interpretation or instructions, and there have been times when I've read it for the third or fourth time, and I stop and I say, "Wait a minute, now I think I understand this," whereas I didn't quite understand it before. It's typical, it's regulatory gobbledygook. You got to be very careful. That thing about 104B, the exceptions, and the fact that a number of those exceptions are not technically in 104B. It's in the the official interpretation of 104B. So it takes a lot. You got to stop and think about what you're reading. It's time consuming. It can be very confusing, and I'm certain there's going to be plenty of confusion going forward. We'll probably do another webinar where we'll start looking at the data fields and looking at all the little things that have to be there. But that's, most of our today, we were talking about people are at least 15 or 16 months away from having to collect the data. The big thing, of course, is to remember, though, you got to try to qualify your situation by the end of this year. Tier 1, Tier 2, or Tier 3, based on those methods that the board or the Bureau approved. So I could go on, but I'm not going to go on because I'm certain you ran out of aspirins in your jar already. But I definitely am interested in looking at the questions, and we will do our best. What we will do is post responses to the questions over the next few weeks. We'll take, one or two at a time, and they'll be available on the Geodata Vision website and on the M&M website.